All right, good afternoon, everyone, and welcome to the Dallas Public Library's Ask the Expert program. Today we have uh, Dallas Morning News writer Virginia Hammerly with us today. She's going to discuss um, wills and estates and give us some information regarding that. We have lots of questions that were submitted, so we may not get to all of them, but we will do our best to answer what we can and help you possibly get some information on answering the rest. So we will turn it over to Virginia, and we hope you enjoyed today's program. Please keep your self muted. We are recording this program, so if you don't want to be on camera, you may turn off your cameras if you like to do that. You can post any questions you have in the chat as we go along, or raise your hand and ask to unmute if you want to ask your question out loud. So we will turn it over to Virginia. Thank you for attending today's program.
Thank you, Paige. So my name is Virginia Hammerly. I'm an attorney. I've been an attorney for a pretty long time, almost 40 years, which makes me kind of older. What I'm going to try and do today is to just kind of take you through the estate planning process and then briefly touch on a little bit about the probate. So there were a lot of questions that were submitted. I'll try and address those as best I can while I'm talking. When I'm finished, if there's any additional time, then we'll see if we can go through those and address them one by one. So to start out, let me tell you that this is a big topic, and I'm going to show you the book that people kind of consider to be the Bible. It's Johansson's Estates Code. There's another version that's called O'Connor's, and it just has the very basic information on estate planning and probate and some of the laws that touch it. So whenever we end up with a touchy or thorny question, we start out with that, and then we do our research and we go from there. The documents that we're going to talk about are the Magnificent Seven documents, and they start out with a will. Now, there were a lot of questions about wills versus trusts, and I'll see if I can get to those, but trusts are another huge topic. And so let me just generally say, you need to consider when you're thinking about what you want to do for an estate and how you want to arrange things on whether or not you're okay with going through a will-based estate plan or whether you want to do a trust-based estate plan. If you're one of those people who came to us from another state like California or Florida, then you most likely came into the state with a trust. And the reason for that is California and Florida do not have friendly probate. So Texas has a very, very, very friendly probate system. It's called an independent administration. And if you have an independent administration, you're only going to touch briefly with the court when you go through probate. It's a simple system. If your will is properly set up with the right language, then you're not going to have to post a bond, and you're not going to have to go to court to get permission to sell assets or to pay off creditors or to make the final distributions to the beneficiaries. So where in California and Florida and other states like that, you would have to do a trust because the other states have probates that might take 2 years and, consume 5 to 20% of your estate assets to handle it. In Texas, we just don't have that problem. So let's start off with a will. In Texas, a will has to be in writing. And to be valid, it has to be either in completely your handwriting, and from completely, I mean from the date to the property description, to all of your bequests, to your signature on the bottom, or it needs to be typed and witnessed by 2 people, okay? And the people who witness it should not be beneficiaries. In order for it to be self-proving, so you don't have to drag those witnesses into court, you'll also have to have it notarized. So there's a specific affidavit called a self-proving affidavit. Now, in terms of, is there a set form in Texas for a will? There is not. Can you go online and pull down a form? Sure, absolutely. You can go online and pull down every single thing that you need. Will it be a good form? I have no idea. And you probably won't have any idea, and we probably won't find out until we get to court. So I would suggest, as I'm going to suggest with all these documents, that you spend a little bit of time and money up front and you go see a lawyer to get it properly drafted. And that way you don't have to worry about issues regarding whether you properly set out beneficiaries, whether you properly put in the right names, whether you allocated all of the assets the way they needed to go, whether you have all the language for the independent administrator without bond to be set up. It can be done properly, and it'll save you a lot of time and effort, and your beneficiaries a lot of time and effort down the road. So the will only takes effect after you're dead, okay? Once you die, we have to come up with the original will and show it to the court to show that you have not torn it up and that you have not voided it. And the presumption is, if we can't come up with your original will, then the presumption is that you destroyed it. And if that's the presumption, then we're either going to go back maybe to a prior will, or we're going to do a complete heirship proceeding, which can be expensive and lengthy. So number one, after you have the will drafted, you need to keep it in a safe place. And no, I don't recommend a safety deposit box. And I don't recommend that you leave it with your lawyer, because lawyers have a habit of, dying or going out of business or just going away. So it needs to be someplace safe, and you need to let your executor know where the will is. Okay, so now let's talk about the people who are addressed in the will. You are called the testator. You're the one who made the will. It's your will. It should set out everything that you want to do, and it should dispose of all of your property, okay? The people that you leave property to, they're called your beneficiaries or your distributees. And the person who is ultimately going to take that will, file it with the court, get it probated, and then handle everything with the probate, that is your executor, okay? If your estate, which is what happens, what gets opened up by the probate court, if your estate gets administered by somebody other than your designated administrator, your executor, then they're known as an administrator. So that's a little bit about the terminology used in a will. Now let's go back kind of to the very basics, and that is, what is actually going to pass in your will? Well, what passes are called the probate assets. So the probate assets are everything that doesn't pass outside of your will. So what passes outside of your will? It's going to be anything that you have deemed joint with the right of survivorship, so it's titled that way, or where you have actually named a beneficiary. Now, when you think about what kind of assets can you do that with, Texas they've gotten pretty aggressive with this on assets that pass outside of probate. They're doing their best to make it as friendly as possible. In the meantime, as they're doing that, they're also really confusing people's estate planning. And here's why. A lot of people will come in and they'll say to me, well, I've got all of these assets. I've got accounts out here, and I've got IRAs, and I've got 401ks, and I've got a house, and I've got a car. And I want everything to go first to my wife and then to my 2 kids. And I'll say, well, that's great. Let's talk for just a second about these bank accounts that you have. How are they titled? Hadn't really thought about that. Well, I guess they're in my wife, my spouse, and my name, right? And I'll say, okay, well, did you check the box that says they're joint with right of survivorship? Don't know, have no idea. Well, did you name a beneficiary on the account after that? Don't know, have no idea. If the account is joint with right of survivorship, then when you die, your spouse or whoever you have on there as an account holder is going to take it, and that is a non-probate asset. So it's going completely outside of your will. Your will does not control that. So now let's look at your IRA. Is there a beneficiary named? If so, that is not going to go through your will. It's going to go completely outside of your will, and it's going to go to your beneficiary. So now let's look at your car. So with cars, you can actually, in Texas, designate a beneficiary. There's a form for it. I think it's called VTR-121. but it's on the motor vehicle website. You can download it. You have to go stand in line in order to, at least last time I checked, to go ahead and file it and file a little bit of money with it, pay a little bit of money, but you can designate a beneficiary. With your house, you can designate a beneficiary. It's called a transfer on death deed. So, and I'll go into that in just a second, a little bit deeper, because those are a little bit confusing. So when we go through here and we start looking at all of these designations, then you realize, well, wait a minute, maybe when somebody dies, maybe when I die, if I have gone ahead and said, I want 10% of my money to go to charity and all of my estate is going by beneficiary designation, charity's not going to get anything because nothing is going through your estate as a probate asset. So when you approach the idea of estate planning, you need to have a really good idea, and it doesn't have to be perfect, but just an idea of here's my assets, here's the dollar figure in them, here's the value of them, and here is what I actually want to leave and to whom. Sometimes when we get into situations like a blended family, instead of naming a child of a prior marriage in a will, maybe what we'll do is we'll name them as a beneficiary of an account. And that way we don't have issues where we may have a second spouse dealing with a child from a prior marriage and we've got some little personal family dynamics going on that are going to make that an uncomfortable situation. Okay, so let me step just a moment to the next thing, which is we're a community property state. So community property goes into every single thing that you're doing. If you are married, you own an undivided 1/2 interest in everything that was accumulated during marriage. And the presumption is that everything that you own is community property. So if you accumulated something by your hard work, even if you've taken extraordinary steps to keep all of your money in an account in your name, if you're married, half of that account is your spouse's by law, okay? What you inherit and what you're gifted and what you came into marriage with, that's all considered to be separate property. So when you die, you get to leave your separate property and an undivided 1/2 of your community property. And that's all you get to leave. You don't get to leave 100% of the community property. You don't get to leave any of your spouse's separate property. You only get to leave your interest in the community property and all of your separate property. So now we've got another category that you need to be aware of. And that is when you come in to do estate planning, you need to know, do I own this asset 100% as separate property, or do I own an undivided interest in the community property? And that goes to the underlying issue of, do you have a marital property agreement? If you have a written marital property agreement, when you go see your attorney to do your estate planning, take a copy. It's a really important document to determine what it is that you're leaving in your estate plan. All right, so that's just kind of a brief overview of what we're doing when we do a will-based plan. Now let's go another step and let's talk about trusts. I don't include those in the underlying description of a Magnificent Seven documents because not everybody needs a trust. And you may have gotten all sorts of little brochures inviting you pre-COVID to little luncheons and dinners for estate planning where somebody's going to give you this big spiel that if you don't have a trust, you're an idiot and your neighbors all have a trust and they have to have a trust. But I'm here to tell you it's not true, okay? A lot of people do not need a trust. So whether or not you need a trust depends on your specific circumstances. Now, let me give you a couple of examples of when you would need a trust. One example would be if you have a blended marriage and you want to set aside some kind of interest for your spouse, but you ultimately want your kids from a prior marriage, or maybe your kids from both marriages, your current marriage and a prior one, to end up with the ultimate ownership of the asset. A trust is a good place to kind of leave those assets, give an income or however you want to invade it to your spouse, your current spouse, the second, and then make sure the remainder is there for the kids. Another situation when you might need trust is if you have a special needs beneficiary. So you have a child who has special needs. If you leave money outright to them, you're going to disqualify them from government programs. In that case, you're going to want to need, and you will need a special needs trust to make sure that you're doing right by them. Another situation is when you own real estate that's outside of the state of Texas. And that goes back to the whole sovereignty thing. As much as Texas likes to think it's in charge of everything, it cannot adjudicate ownership of property that's owned outside of Texas. So if you moved here from California and you kept your house in California, well, number one, God bless you. But if you kept your house in California, then you probably want to keep your California trust, or at least a trust that owns that house, because we don't want to go through a separate probate in California, nor do we want to do one in Colorado. We really don't want to do one in Mexico while we're at it. So if you own that, then you do need to strongly consider having a trust. If you have a vacation property where you want to reach out and make sure that there's money there to fund the vacation property, and you have somebody who's going to determine, who gets what weekends in July, and you want a specific person to do that, then you may want a trust. Conversely, you might want something like an LLC. Just kind of depends on how you do that. Estate taxes used to be a huge reason why we would do trusts. Now, federal estate tax exemptions have kind of been in the news lately because there was a kind of a change in Washington, D.C. recently. You may have read about it. And there's been a lot of movement on what they're going to do about estate taxes. So let me touch on that briefly. If you're a Texas resident and you own real property only in Texas, Texas does not have an estate tax. We don't have a beneficiary tax. We don't have an inheritance tax. Texas is a great place to live in, and it's a great place to die in. So you don't have to worry about a state estate tax. But there is a federal estate tax exemption, and it's a combined federal estate and gift tax exemption. Right now, the exemption is $11.7 million. And I'm not here to give you all of this tax advice, because the book I just showed you, all of the tax stuff is like 3 volumes of that. So I'm not going to do more than just do kind of a general overview. The deal is right now, if you have assets of less than 11.7 million for federal estate tax purposes, then you're not going to owe federal estate tax. And that's a per person exemption. So together, you and your spouse can own $23.4 million. And that's good up until 2026. At that point, the little law that raised it is going to go back. And so we're going to go to a $5 million with some escalators, okay? What that dollar figure is going to be, I'm not sure. Estimates are between 6.2 million and 6.5 million, but I don't know. So if you're under the federal estate tax exemption amount, then you will not at this point need a trust strictly for avoiding the federal estate tax. Before we got up to that high of an exemption, a lot of people would put these kind of elaborate estate plans together where you had to have a flow chart, and you went down and we had a family limited partnership and we had this trust and we had this trust. And the whole idea was to get it out of the estate so it didn't get taxed. So are they going to do anything with the federal estate tax exemption? I don't know. I have no idea. It pays to pay attention to it. There's 2 other things on the federal estate tax and inheritance that you need to think about. One is right now, when you pass away, if you're in Texas, your separate property and the entire amount of the community property, not just yours, but your spouse's, is going to get what we call a step up in basis, which means that for capital gains purposes, the bottom figure is going to be the value as of your date of death. That's a great benefit. There is a lot of talk, and there was an announcement about some legislation that was going through where they were basically going to change that. And you were going to, the proposal is, and I don't know how far it's going to go, but the proposal is that when somebody dies, it's considered a sale for capital gains purposes. And so there would be a capital gains tax that would immediately be assessed. Just might want to kind of keep an eye on that. That would be a change. The other part is portability. So the portability is when your spouse passes away, if there's any unused federal estate tax exemption, you can file a return with the government and you can actually port that over to your own estate tax exemption. So it tags on top of it. So what I'm telling people right now is if somebody passes away, then their survivor or their executor needs to get a CPA and needs to go in and have this big discussion about what needs to get filed. Okay, so we've gone down the lines of whether or not you need a will. And I'll just tell you, even if you have a trust, you always need a will. It's always a sweep document. You've got to have one, okay? And now we've gotten to, do you need a trust? What's in a trust, what you fund into a trust, is not going to go through your probate estate, okay? If you fund it during your lifetime, it's going to stay in the trust. Your death is going to trigger some things within the trust, but it's not going to be part of your probate estate. So people who have a trust-based estate plan have to do a couple of things. One is they have to set up the trust. If they don't want to go through probate, then it has to be an existing trust. So it's a standalone document. There's a lot of flavors of trust, and I don't have time to go into all of them, but there's a huge number of different kinds of trusts that you can do that do different kinds of things. If you want to use a trust-based estate plan, then what you need is you need to fund your assets into the trust, or you need to make sure the trust is a beneficiary of the assets so they don't go through your probate estate. And that's how you avoid, if you're using a trust-based plan, that's how you avoid going to probate. Do you need to avoid going to probate? For the reasons I just gave you before, probably not. It's a very easy probate system, but some people don't want to go through probate. So the trust is out there if you'd like to do that, okay? So that's the basis of setting up for what happens to things when you pass away. Now let's move to some of the ancillary documents. And for all but one of them, these are things that will help you during your lifetime, okay? And one of the things that we want to avoid is having disagreements and fights over you and your assets when it comes time that you can no longer handle things. So the first document we use for that is called a durable power of attorney. And that's a financial power of attorney. We call it durable because we don't want it to go away when you become incapacitated. We want it to stay valid. So it's durable, okay? It's financial because it's only going to handle your financial things. So contracts that you would sign, things that you would sell, investments that you would make, even gifting, all of those can be delegated to an agent under a durable power of attorney. Now, whether or not that power of attorney is immediately effective, such that when you sign it and you walk out the door, your agent immediately has power, that's up to you. If it's not immediately effective, then we call that springing. We, most of us being attorneys, don't do springing powers of attorney anymore for the reason that in 2017, the law in Texas changed and they took what had been a very small statute on power of attorney and they made it into a whole section. And one of the things they did was they said that third parties had to accept it. And that was big because prior to that change, the banks and the financial institutions would just ignore them. And they would say if you did not sign off on their form of a power of attorney, they weren't going to give effect to it. Well, Texas in 2017 said, no, that's not right. The financial institutions can't make you sign their forms and use their forms. They have to accept this durable power of attorney unless they give you in writing one of 11 reasons why they're not accepting it. So back to the springing issue. One of the reasons they can give is to say that we don't think you, principal, are incapacitated. And therefore your agent, your attorney, your power of attorney is not sprung into being. And therefore your agent doesn't have any power. And so that obviously is an adverse effect. That's not where we want to go with that. So we make them presently effective. If you don't want your agent to have existing power, then don't give them a copy of your durable power of attorney. Now, with the new durable power of attorney, we can also do what we call superpowers, and those are very cool, okay? So with the superpower, and you can say you do or do not want your agent to do this, but with the superpower, you can say that your agent, for example, can set up a trust for you, that your agent can fund a trust for you, that your agent can delegate the agent's powers to either somebody else outside of your list or somebody on your list. Your agent could set up a survivorship provision on your account. Your agent can make gifting, again, within the provisions and within the powers that you want. So the durable power of attorney, although at least in my practice, we use the basic statutory form for the basis of it, and then we've added 3 or 4 pages worth of additional language. The durable power of attorney statutory form comes with all these definitions, which is great because if you didn't have that incorporated within your power of attorney would end up being 50 pages long, and that's not going to help anybody. Nobody's going to want to read that. So the durable power of attorney is an extremely important document. By statute, if you can't make your financial decisions and you don't have a durable power of attorney in place, the only way we're going to be able to handle your financial position is to get a guardianship. And we want to avoid guardianship at all cost. So that's a very basic document. The next 3 documents are medical documents. The first one is a medical power of attorney. So the medical power of attorney only comes into play, number one, it has to be in writing, but it only comes into play if you're incapacitated. And your incapacity can come in and then go back out. So if you're in the operating room and you're on the table and you're under anesthesia, you're clearly incapacitated. And if there is a medical decision that needs to be made, then your agent under your medical power of attorney is the one who's going to make that decision. When you come out and you're no longer under anesthesia, then you get to make your own medical decisions again because you're no longer incapacitated. Obviously, the person you designate for your medical power of attorney needs to be somebody who thinks the same way you do and is going to go ahead and honor your wishes for what you want done on medical procedures. So your medical power of attorney needs to be somebody who is, number one, willing to take the time to do it. Number two, has the know-how to figure out what's going on with everything that's going on medically. And number three, shares your sentiments on how things should go with you. Medical power of attorney is extremely important. If you do not have a written medical power of attorney, there is a statute that sets out who gets to make those medical decisions for you. It's going to start out with spouse, and then we're going to adult kids, and then we're going up to parents, and then we're going out to siblings, okay? The problem we've got if we rely on the statute is if there is a disagreement, then somebody's going to ask for a guardianship because none of the doctors want to be put in this position where we've got 2 kids that are warring over whether or not, you get your left leg amputated or whatever medical decision there is out there that you can't make. So if they don't do that, then the court's going to appoint some temporary guardian who's going to go out there and, make that decision about amputating your leg. And we don't want to do that. So when you do a medical power of attorney, you're going to designate your agent, and then you're going to have your backup agent and your agent before then. Okay. Another thing to think about is if you have somebody you're leaving all of your money to, and you've also designated them as your medical power of attorney, you just kind of need to think through those ramifications. It's very, very fact specific to your family regarding who it is you're going to designate as an agent. Next document up is a HIPAA release. So this is a separate document, at least the way I do my practice. The reason is on your medical power of attorney, your agent, if they have authority because you're incapacitated, can access your medical records. But if there's a question about your incapacity, or if you've regained capacity enough to at least be conscious, but maybe not to understand the ramifications of the medical procedures, a lot of times doctors and hospitals just refuse to deal with your agent. And they will not give them that information because they'll say, well, you know what? She's not incapacitated anymore. So the HIPAA release gives your agent that you have named, and you can name 3 or 4 or 5 people if you want to, they're not in any particular order, the ability to get your medical records, find out what kind of drugs you're on in the ICU. They can't give a direction, but at least they can get the records and, sound the alarm if something's not going on the way it needs to go on. The third document for medical purposes is the directive to physicians. And we also call that a living will. So there's a couple of different things that people will go by on, how we call this, but basically the document is set up by statute in Texas. I believe every state has a statute that has some version of a living will or directed to physicians. But the Texas one deals with 2 situations. And the first situation is that you have been diagnosed with a terminal condition that's going to lead to your death within 6 months. And the question comes up, do we or do we not prolong your life through artificial means? So we're talking the feeding tube, we're talking artificial hydration, we're talking the ventilator. So do we or do we not hook you up to that? Now, just because you've signed this document doesn't mean that it supersedes what your wishes are if the time comes. If you're in the hospital and you're saying, hey, I think I'd need a feeding tube, and they come in and they wave this document in front of you and say, oh, no, you signed off that you didn't want a feeding tube if you were here. That doesn't cut it, okay? So you can supersede this document verbally, whether you have capacity or no capacity. But it's a very important document just so your doctors and the hospital and your agents, your kids, your spouse, know what your wishes are. This is your time to tell them. The second situation that comes into play is if you've been diagnosed with an irreversible condition that is going to continue to lead to your deterioration, although not necessarily to your death. And the example we use on this one is dementia. So as you know, people, when they have dementia, they can go on for a pretty long period of time. There have been a number of studies on that. Sometimes it's a fast moving dementia and it's over within a year. And sometimes people live with it for 10, 15 years. And so when something like that happens, and you come up with pneumonia, or you come up with some kind of situation where, again, there's artificial means to keep you alive, this is your chance to tell them do or do not do that, okay? The directive to physicians can be as specific as you want it to be. You can use the language in it that you want to use in it. So if you do have and have received a diagnosis of a terminal condition, you can state in there that you don't want to receive the 4th round of chemo, or that you would prefer not to have the brain surgery to relieve the Parkinson's. You can be very, very specific on what you want to have done. And for that reason, it's an extremely helpful document. There is another document that I do not draft up, and that's called a do not resuscitate document. The do not resuscitate document is one that is doctor created. So you would get that from your doctor's office. You would have it if you ever went into hospice, which is usually, the last 6 months, or at least available for the last 6 months of life, according to how the doctor sees it. The do not resuscitate is going to say, if I have cardiac arrest, if I stop breathing, just don't resuscitate me. So it is very much an end of life document. I have known 2 or 3 people who have had several bouts of cancer. They haven't been end of life, and they've talked their doctor into giving them a DNR. I have had older clients, 99, 100 years old, who have been very, very fragile medically, and they've talked their doctors into giving them a DNR. I respect those choices, but it's definitely between you and your doctor, and it's something that a lawyer acting alone can't create and can't make effective. All right, so the next document is called a declaration of guardianship. And if you remember back when I was talking about the durable powers of attorney and all these other documents, I mentioned that you want to avoid guardianship. I do a lot of guardianship cases. I get court appointed as an attorney ad litem or a guardian ad litem. I have represented people who are proposed wards in guardianships. I have represented people who are applicants in guardianships. I think highly of the Texas system, which is much stricter than it was 10 years ago. So we've got a lot more safeguards in place. But I can tell you that guardianship is nowhere that you want to be. In Texas, there's two kinds of guardians. One is guardian of the person, and the other is guardian of the estate. A guardianship is a court-created relationship that starts with an application. It can be a court-initiated guardianship with the application, which makes us fairly unique in the United States. In Texas, not many states will allow their courts to initiate a guardianship on its own. As a proposed ward, you would get an attorney ad litem to represent you. There's hearings, there's all sorts of discovery, there's fees that they get paid to everybody and their dog. The court would have to find that you are partially or completely incapacitated, temporary or permanently, and would decide whether or not you needed a guardian to help you make personal decisions, which would be guardian of the person. And those decisions would include where you live, what you eat, how you cut your hair, whether you live or die, or guardian of the estate, which is financial. So there's all sorts of the guardianship code is getting increasingly more complex. There's step downs on the guardianship not to have it, but in terms of estate planning, Texas allows you to tell the court who, if you needed a guardian, you would like to have appointed as your guardian. And that's a big deal. So on this, you can say, Judge, basically, I don't want to be in a guardianship, but if I needed one, I would like my sister Sue and my brother Al and my niece in this order to serve as my guardian of the person, and then as my guardian of the estate. I want these other people to serve. And the court takes that into consideration. The court isn't bound by it because the court might find that, I don't know, your brother or your sister or your niece are not suitable to serve, or they may not want to serve. And so the court is not bound by who you say you want to serve, but does give preference to it. More importantly to me, though, in terms of family dynamics, is that you can put in there who you do not want to serve as your guardian. So you can completely wipe out a whole branch of the family in terms of whether or not they can serve as your guardian. And the court is prohibited by law from appointing those people. So it's a very, very helpful thing. I've had clients who have come in and, given me a name or two. And then I've had people who've come in and they've given me a page of names of people they do not want to serve as their guardians. And that's fine. However they want to do that, that's fine. So we'll put that in. This particular document usually doesn't see the light of day unless there is a question about the guardianship and somebody's seriously threatening one. The other side of a guardianship that you need to know about is if they're giving those powers over you to somebody, they're taking those powers away from you. So if they're giving somebody the power to pay your bills, they're taking that power away from you. They can also take away your power to drive, to vote, to get married. I mean, it can take away a lot of your rights very quickly. So we want to avoid guardianship. Right. So the last document that I throw in there that is just a very basic document is the designation of burial agents and your burial instructions. So this document is actually a wonderful document. It is something that funeral homes love because they are now the chance that somebody's going to sue them for following one person's instructions they go to almost zero. And funeral homes have been held liable for taking one relative's instructions over another one's. So they get very excited and they have everybody who could possibly sue them sign off in order to decide whether or not they're going to cremate somebody, which is kind of irreversible, you may have noticed, or bury them, where they're going to bury them, who's going to determine what kind of religious ceremony they have, or whether they don't have a religious ceremony, where the ashes are going to be scattered, where they're not. And all of this you can put in this particular document. So it's based on statute. It has statutory protections. Your agent has to agree after you die to accept the liability and the responsibility of being your agent. Agent doesn't have to post a bond or anything like that, but what the agent does have to do is come up with the money, unless you've made pre-arrangements on how all of this is to get funded. Your agent's entitled to be reimbursed out of your estate. It's an administrative expense. It comes off the top, but that also kind of presupposes that your estate has money, but your agent does become personally liable for any of those expenses until they get reimbursed. So it's an honor to be named as an agent under that, but it is also a bit of a chore. What can you determine? You can make arrangements for that, whether you're going to be cremated, whether you're going to be buried, whether you're going to be buried in a mausoleum, if you're buried, where you're going to be buried, what's going to be on your headstone, if you have a headstone. If you decide to be cremated, what's going to happen to your ashes. You can make it binding on your agent. Everything that you put in there is actually binding on your agent. Who is going to sue them if their agent doesn't do anything? Well, I guess that kind of depends on your family dynamics. But it's an important document. I've had people, again, append 2 or 3 pages of songs they want sung at a ceremony. I've had people tell me that they just want a big badass party, and that's fine. That's what I put in there, that's what they want. Some people want to get made into diamonds. That's fine. I'm happy to put that in there too. Won't put in anything illegal. Some people want green burials. That's fine too. On the portion regarding whether or not somebody wants their body to be donated or whether there's an organ donor, we can put that in there. It's probably not the best place for it though. So we would put a little paragraph in there that you've made other plans. If you want a whole body donation, you need to go ahead and get online and get that set up so you're in a national database. You can make reference to it in the document, but we don't want some situation where the document can't be found and all of a sudden, you're buried and that whole body donation thing doesn't happen for you. When you designate your agents, you designate them in order. So the first agent has a chance to act. I believe the statute sets out they have to do so within 6 days, or that's considered a declination to act. And then the next person up has 6 days to say or not. Don't hold me to that particular time period, but it's 6 or 10 days in there. That document is given to the funeral home for final disposition, and everything goes along fine. So those are the base documents that we have. Now let me talk about a couple of little extra documents. Talked briefly and touched briefly on a transfer on death deed. So a transfer on death deed is a statutory document set out in the state of Texas. A lot of states have a similar document available out there. What happens on a transfer on death deed is when you die, first, you sign off on the deed. You state who you want the property go to when you pass away. The deed has to get filed in the deed records of the county where the property is located while you are alive. So don't do a transfer on death deed and stick it in your middle desk drawer and tell your executor where it is. Okay, that doesn't work. It's not working that way. It has to be filed. Transfer on death deed, you can revoke anytime you want to. On the transfer on death deed, once you pass away, the person that you have left the property to just files an affidavit in the deed record saying that you've passed away. We don't file the death certificate because the death certificate has all sorts of personal information on there that would just be perfect for an identity thief to have. So we don't file the death certificate. But we file the affidavit, and that serves to show passage of title to the person you named as a beneficiary on your transfer on death deed. So what's the disadvantage to a transfer on death deed? It's got a 2-year clawback. It's a huge disadvantage. What that means is if you have arranged your estate so that everything's passing by beneficiary designation and there's not enough left in your probate estate to pay off creditors, the creditors have the right to go in and claw back into the estate anything that you have left by beneficiary designation or right of survivorship. All of those assets are subject to a clawback. For some of those, I mean, it's cash. assuming that your beneficiary transfer on death deed, whoever your beneficiary or right of survivor hasn't spent everything, then that's money that would come back into the estate. But on real estate, title companies don't like to give title insurance if there's a chance that that land is going to be clawed back into an estate. And so the problem with the transfer on death deed is it essentially freezes stuff for that 2-year period of time. It's very hard for your beneficiary to sell that property. You may be able to find a title company that will do something about that, but I'm just here to tell you it's tough, okay? And that's a disadvantage. On the other hand, if you leave it to somebody in a will or the property is owned by a trust, then that's just going to get distributed out after all the debts are paid. And so at that point, the person it gets distributed to, the beneficiary, is probably going to be able to sell it and get title insurance to guarantee the title as it goes by. There's another way to transfer property. It's called a ladybird deed. So ladybird deed is not by statute. That statute just doesn't set it out. A ladybird deed basically gives an interest to a beneficiary. It's a present interest. And what happens is the person who granted the ladybird deed, who then dies, the person who receives the ladybird deed now has this present interest in it. So the good side about that is there's not a statute that says there's a clawback. The bad side about it is a creditor could still reach out and get it. And because there's not a statute, sometimes people are a little reluctant to accept it. A ladybird deed is usually used when we're doing Medicaid planning because it's accepted so far by the state of Texas for taking the house out of the estate. So those are the basic documents that we have out there. There have been a couple of questions about Medicaid. So let me talk briefly and touch on that. Again, Medicaid has its own book. Again, that's thick. A lot of Medicaid is based on how the policy is being interpreted by a particular state. And so things change on Medicaid pretty often on how to do appropriate Medicaid planning, and what worked 2 years ago may not work now because there's been a change in policy. But briefly, Medicaid is a state federal program that provides for care for somebody. Sometimes there's a number of programs that come in under the umbrella. The most commonly understood one is somebody who needs nursing home level care. Where we come into it with estate planning is when the state has been paying Medicaid money out, it has a right when that person, the recipient, dies to go back against that person's estate to get repayment of that money. And so if you have somebody who is receiving Medicaid and they pass away, then their entire estate, and again, we're talking about the probate estate, what goes through probate, is subject to what we call a MERP claim, which is a Medicaid Estate Recovery Program claim. And that has to get filed. The claim falls down to the lowest level. It's down with credit cards in terms of priorities for payment, but it's still there. So the ladybird deed is used to get the house out of the decedent's estate. So it is not part of a MERP claim. So again, when we go through and we're talking about all of these kinds of plans, it's never a cookie cutter situation. It always depends on where you are financially, where your assets are, where you are with your health, what your family dynamics are. Who do we need to protect you from during your lifetime? Who do we need to protect your estate from? Who do we need to protect your estate for? How are we dealing with creditors who are out there? What are we going to do about debts that are out there? What about entities that you may own, which may have their own buy-sell agreements on death? Are you part of any kind of partnerships? Is your death going to trick a foreclosure someplace because you've guaranteed something? It all goes into the mix. and let me circle back to where I started. If you start out going to a meal seminar where they're going to tell you that their cookie cutter plan is going to work for you, and you're a fool if you don't pay $10,000 by the end of the meal to get this nice little red book that's got lots of blanks in it, that's just not a good plan, okay? Nor is it a good plan to go online and do your own planning. Even the most simple of estates can get messed up if things go wrong. If you sign off on your will and it only, as an estate that I just saw, the will left specific assets but didn't leave the residuary to anybody. And so what happened was we had 5 or 6 people who got specific cars and specific, a house and maybe a necklace and something like that, but it didn't leave the rest of, it didn't have a residuary clause. And so there was no cure language for what happened to the rest of the assets in the estate. And there was no instruction language on what debts went with what assets. And so in that case, yes, we had a will. Yes, it was witnessed. Yes, it got admitted to probate, but we had to do an affidavit proceeding, an heirship proceeding to handle what happened to the rest of the assets. And that was because somebody went online and they pulled down, a will online, and they thought it was a really good thing. Same thing with powers of attorney. The medical power of attorney is a statutory form that right now, unless the legislature changes it, and they're acting right now. I didn't know if you knew that in Texas. They're meeting right now, and they always make changes. But unless the legislature changes it, the medical power of attorney statutory form is mandated. Under the statute, you're supposed to use that form and no other form. The durable power of attorney is recommended as a base document because it comes with all these statutory protections and definitions. That's not something that you're going to go online and get with all the options that you've got. The HIPAA release, those are federal and state law on HIPAA. So again, unless you get one that's been drafted up specifically for Texas residents, it's not going to cover it. The directive to physicians, hospitals like to see a base form that has the statutory protections in it that they're used to seeing. They don't like seeing another state's form, and they don't like to see a generic form. So our whole goal is to make sure that these documents work for you when you need them, because by the time you need them, it's usually too late for you to go back and amend them, quite frankly. So let's get to a couple of little questions in here. And we had, just so you know, about before this talk ever started, we had over 6 pages of questions. So I'm sure that I haven't gotten to all of them, and I can't address all of them, and I can't give you specific legal advice on your specific situation. But let me see if I can at least address some of the generic questions that are out there. So question 1, if I already have a will in hard copy but need to make a change, what is the best way to make that change? Let me start out by saying what not to do. Do not take your written will that was signed before 2 witnesses and a notary and cross it out with a pen and write in your change, okay? Judges don't like that. It's not effective. It doesn't work, okay? At worst, or at best, they'll ignore it. At worst, they'll toss out your whole will and say that you meant to void the whole will. So don't do that. The appropriate document to make a change is called a codicil. It has to be executed with the same formalities of your will. So you need 2 witnesses to it. You have to sign in front of them. They sign in front of you. And if you want it to be self-proved, so we don't have to drag your witnesses into court to prove up that they actually signed it after you die, then it needs to be notarized with the appropriate language. That's called a codicil. The bigger question, though, is what is it that we're changing? And is it a big enough change that we need to go in and just do a new will, which is sometimes a lot easier to do. So you can imagine if in your will you left 1/2 of your property to your son and the other half to your daughter, right? And then you say, oh, you know what? I really don't like my daughter anymore. So I'm going to leave 100% of my property to my son. And you say, well, I'm going to go ahead and do this codicil, and that'll be great. Well, what happens is we have to admit both the original will and the codicil. And so your daughter is going to see that she just got cut out from half of your property, and she's not going to be happy. And if she's not happy, chances are she's going to start coming up with reasons why your codicil was not valid. Think how much easier it would be if you just did a brand new will. All we had to admit was your brand new will. And the will said, I leave everything to my son. And then you specifically make a statement that you have disinherited your daughter or make no provision for her in there. At that point, I've got one document. We prove up one document. I don't have a prior document that's sitting out there that gives her half the estate. So again, codicil if you're going to amend it. If it's a big thing, a big change, or if we're under our second or third codicil, my goodness, because then I've got to come up with the original and all of my codicils. Just go ahead and do a brand new will. It just is so much cleaner with that. Okay, my husband and I are in our late 30s and are expecting our first child in June. My father has strongly suggested we create an estate plan. Where do we start? And any special considerations for a plan benefiting a minor child? So if you have a minor child, then you want to make provisions for a guardian of the minor child in case both parents are deceased. And you get to choose, again, who the guardians would be. You get to name them. A court will give great sway to who those guardians are and what your choices are, and will really do its utmost best to make sure that your choices are honored. If you name somebody as a guardian who turns out to be convicted of embezzlement or maybe has a child pornography charge out there or two, chances are they're not going to be named as a guardian. But assuming they qualify, the court will give sway to that. Now, the plan benefiting a minor child for money, this is a case where a trust would be appropriate. We don't want that child to have full possession of money at age 18, which they're going to do if it's just left outright to them. We want to make sure that we have named somebody who can be a good trustee for the child up until whatever age that you want to name. It could be 25, it could be 35, it could be 45. However you want to set it up, we want to make sure that you've got your standards out there on how you want the funds dispersed, whether you want to encourage education, whether you want to pay for college, whether you want to go on for advanced degrees, whether you want to pay for a first house, whether you want to pay for a car. And if it's a car, do you want a Kia? Do you want a Ferrari? I mean, what are our standards here that we want to do? So those are situations where you definitely need to come up with that. And while you're thinking about that, you need to go ahead and think about what exactly are we leaving money-wise for that child. I always recommend a life insurance product. If you've got a minor child and your estate's less than $5 million in cash, it's just a good idea to make sure that we have liquid assets that we can take care of the child quickly, and that those are there to fund whatever trust that we have set in place. So that will keep you out of trouble and it will take care of your child. If a person passes and leaves a will, do you still have to go to court? No. It depends on what's in your estate. Depends on whether or not we can do a shortcut. If you want your will to be recognized by a court and the provisions given effect, then we have to go to court to have it declared a valid will. Until you're dead and a court declares it as a valid will, it doesn't operate to pass any kind of property. But whether or not we actually need to do a probate is very fact intensive. So your best bet would be when a person passes away, call up the lawyer, maybe even before the service, and get an appointment to bring that final document in and sit down and say, look, here's our mix of assets, as much as you know, here's whatever issues are out there, and then we can address whether or not we want to go ahead and do a probate. Now, a little COVID discussion here. Courts have been going by Zoom since COVID. So we have had all sorts of Zoom hearings. For most courts, those are the only kind of hearings that we have had. We haven't had jury trials in Texas for the most part. There have been one or two intrepid courts that have tried to hold a jury trial or two, but they have not really been that successful. So the hotly contested cases have not really had jury trials. If it's a non-jury case, we have gone ahead and done a lot of cases like that. But there is a backlog right now with a lot of courts. In Texas, we have 10 counties that have probate courts, and they're the ones that If the person has a residence in that state, in that county, that's the court, one of the probate courts that are going to hear that. In the other counties, of which there are a lot, they don't have designated probate courts. And so whoever has probate jurisdiction in that court, and it depends on the statute and where it lands, they've been holding those hearings. Some of the probate courts are pretty current on their probates, and we don't have to wait a long time. There are a few courts that have not been quite as proactive in getting their prove-ups on wills done. And for some of those, there's kind of been a big delay. And so that also factors into what we're doing with probate. For the cases where we want to do a probate and we think a probate is necessary, we want to get those applications for probate on file as soon as we can, because the sooner we get them on file, the sooner we can post notices, the sooner we can get on the court's docket to prove it up. And if all else fails, we've got, some temporary things that we can file motions for and do emergency. But for the most part, if there is a probate that's going to be done and it's in one of those counties that are running a little slow right now, we want to get it on file as soon as possible. Can you have a hearing, or can you admit a will to probate without a hearing? There's some legislation that's pending right now to say we can do it by affidavit. It hasn't passed yet. I don't know whether it will. It would be nice if it did, if anybody's listening to me on this. But until it does, we are still having a hearing. Okay. So the beneficiary designation terms. So joint with right of survivorship, JT next to a beneficiary account means that it's held jointly. If it's held jointly, then everybody who has an ownership interest in the account holds that percentage of an undivided interest. So if I have 3 people and it's held jointly and they're all owners, they each own a third. Okay. A joint designation on an account does not mean that the other account holders are automatically going to get that account when one of the owners dies. It just doesn't pass title. A joint with right of survivorship, and the right of survivorship is a WROS that you're going to see, means that all of the owners on that account are going to go ahead and take ownership of the deceased part of the account when somebody dies. And what you have to do is show a death certificate and your identification, and then you get that person's name taken off the account, or you get to withdraw their percentage of it. And so that's joint with right of survivorship. Community property. Just because something is held by a married couple with both their names on the account does not mean it's joint with right of survivorship. And it does not mean that the surviving spouse automatically gets ownership of the decedent's share. It doesn't work that way. It's the same thing with a house. If I have in Texas, we don't have between a married couple joint with right of survivorship on a deed. So if there is a married couple and they own the house, and that's all we have is a deed, somehow we're going to have to legally get the decedent's name off that house into the person who inherits. And just so you know, if we have a married couple and one of the people has a child from a prior marriage, the spouse isn't going to inherit everything if there's no will. It's just by survivorship and heirship, that doesn't work. So there have been a lot of times when a spouse has ended up owning half of the house, which is the undivided community interest the spouse had anyway, and they end up holding it in ownership with a stepchild or 2. And sometimes that can be a little uncomfortable. So always a great idea to go ahead and put that will in place. I am a Texas resident and own a second home in California. I've been told I need to have a trust because a second home is in California. Do I indeed need a trust along with my will? Answer, yes. Yes, we do not want to do another probate in California if we can at all avoid it. It's not a good idea. Let's see. I want to know how to make my will legal. So whether or not it was legal depends on the formalities with which you signed it. If you already have a document that you signed and you didn't do that in front of two witnesses, then your will isn't legal. If you have a document that you think is your will and you signed it just in front of a notary, your will is not legal. Your best bet is to get a brand new document, sign it with the right formalities, and then we can make it legal. What are my duties as an executor? Well, they're huge. You have a fiduciary duty. I'm sorry about that, but you have a fiduciary duty. When you sign on to be an executor, then you owe that duty to the beneficiaries, but you also have a duty to the IRS. And you are personally liable if you distribute the estate and their estate taxes due. So you were not able to get appointed as an executor without an attorney. At this stage of the game, with the way Texas law is now, you have to have an attorney help you go through probate. So when you interview the attorney to determine whether or not you want the attorney to help you, then I would also ask the attorney, tell me exactly how you are going to help me with this. How am I supposed to know what to do? How am I supposed to know what my obligations are to insure the property, to pull together the stock certificates, to get the information, to, can I get a form to find out whether or not an insurance policy passed to a beneficiary or not? And spoiler alert, you can. What about the inventory? When do I pay creditors? What if I dispute a creditor's claim? What's the right way to do that? What's the timing on distribution? What if I have a beneficiary who's not acting right? What do I do to secure the house after the funeral? That's a big one. You'd be surprised how many people leave the funeral early to go help themselves to, a plate, china, silverware, grandfather clock, obviously the decedent wanted them to have it, right? So all of those are obligations that you've got. You need to take them very seriously. There are some publications out there that talk about it, whether or not, I don't think they're publications that are available on Amazon. We have a little executor handbook that we hand out to our clients when they become executors. It kind of walks them through the process. One of the very important things to do is from the very beginning, after you get appointed as the executor, you're going to get an estate ID number for tax purposes. You're going to open up an executor account and you're going to start keeping a spreadsheet or QuickBooks if you can do those, so that you can account to the beneficiaries for everything that comes in, everything that goes out. You can account to the IRS for that. And so you just need to make sure that whoever is helping you with the probate is giving you the guidance you need to pull everything together so that you don't get in trouble with it. It's the same thing if you're serving as a trustee. If you're going to serve as a trustee on any kind of trust, then you need to realize, and this is true even if it's your own trust, you need to realize that you now have a bullseye on your back. Anybody who is a beneficiary under your trust can sue you for a breach of fiduciary duty. And you've got an obligation to the IRS. If the trust is a separate taxable entity, which it will be after the original grantor passes away, then you're going to have to file tax returns. You're going to have to determine about distribution of income and how assets are invested. If something needs to be distributed, then you're going to have to make those distributions timely. So there's, again, a lot of guidance that's available out there, but I would not dream personally or on behalf of a client, I would not dream of letting them serve in that capacity without having some legal representation that they can go back to and who also can, be a shield for them when it comes up. Can I assign an effective date for gifting 10% of a family limited partnership to each of my 3 children? You can. So a gift is not effective until it's completed. Can you make a gift for the future? Yes, but again, it's not effective until it's completed. So if you're dealing with family limited partnerships, which are a pretty sophisticated type of investment vehicle, then I would suggest that you work with a CPA or an investment advisor on the best way to make that happen, to make sure that you're not running afoul of the gifting laws that are out there and that you're not running into some tax issues on it. Question: I currently have my sister as joint owner of one of my bank accounts to enable immediate access to funds in case I become unable to handle financial matters. Is there a downside to this arrangement, and would a financial power of attorney be better? So these are fact specific. I'd have to know why that arrangement was put in place. I can tell you that if your sister is a joint owner and there is any kind of creditor concern for your sister, then they could reach out and seize 100% of the funds. You may have a defense that your sister wasn't actually the owner of the funds, but at that point, you would be on the defense, and it would be your burden to show that. And that's a lot of expense and trouble that you probably don't have to go through if you set it up a different way. So if the question is, do you want to arrange so your sister can manage the funds in the bank account and disperse them on your behalf? If you're unable to do so, you can give your sister signator rights without an ownership right to the bank account. You can also just keep your sister off the bank account and give her a durable power of attorney. Now, the power of attorney that you give her doesn't have to be a general power of attorney. It can be very specific. So you can say, I am naming my sister as my agent to handle transfers in my account ending in XXXX for the purposes of blank, okay? That way, at least it's a specific power of attorney, doesn't give your sister complete access to all of your funds. It's just for that purpose. And it's probably something, and we'd have to, work on the timing and the language of it. It's probably something that a third party like a bank would give effect to. But that is a much safer way to protect the funds in your account than it is just to give your sister total access to it. If the intent is to have your sister have immediate funds to pay for, say, funeral expenses or something like that after you die, then I have seen people do that, where they have either given a joint ownership or they've named sister as a beneficiary of it. The benefit of naming sister a beneficiary of it is that we don't have to wait for some kind of death certificate in order to give ownership, so that she can access the funds. But again, you have exposed all of the funds to your sister and her creditors with the ownership. So there's pros and cons. If you're really concerned about it, I would prefer that you go to a reputable company and prepay funeral expenses than just to give blanket authority over a bank account.
We do have a few questions that have come in through the chat. If we could maybe try to address a few of those, we're getting sort of 15 minutes left. So let's see. If you prepare a will and move to another state later, I guess question on how to handle that. I don't know.
Every state that I am aware of will recognize a properly drafted will from the home state. So if it's legal in the home state, the new state will give effect to it. That doesn't mean it's the best way to do that. I recommend to my clients, if they're moving to another state, that they go see an attorney in that state to make sure that the documents that they have drawn up are going to be valid in that state. Same way, if I have a client who has moved here to Texas, I'll take a look at their documents, but most likely I'm going to recommend that they get documents that Texas people are familiar with and Texas courts like.
Okay. If the beneficiaries are overseas and do not have U.S. Social Security number, does that mean the executor has to be a lawyer?
It means the executor definitely needs a lawyer's advice. Dealing with non-citizen beneficiaries can raise a lot of unpleasant issues. So I would definitely recommend that they go through a lawyer to make sure that, say, transferring $10,000 to somebody who lives in North Korea isn't going to raise any red flags out there. And make sure they're not running afoul of a treaty or some sort of US law.
Okay. Someone is asking about the MOST document, MOST in Texas. Are you familiar with that?
Right. So my understanding of the MOST document is that that's an end of life document, kind of like directive to physicians. The directive to physicians is the preferred document in Texas, as is a DNR. You can leave extra documents or ancillary documents, but I would use our base Texas documents first. And then if we want to add on to those documents and make them specific, we can do so. We can't do that with the DNR. The DNR is statutory and it's what the doctor has to countersign. But with the directive to physicians, we can go ahead and customize that one.
Are married couples' wills done separately?
I hesitate on this because I believe that there are some lawyers out there who will do joint wills. I will not. Most of the lawyers I practice with will not, but you can do a contractual will. I would never do, and I don't think I've ever seen a joint will. What I have seen and what is an alternative is a written survivorship agreement between a married couple. And that can be used, that's a non-probate document that can be used to transfer ownership between a married couple as long as they both sign it. But in terms of a contractual will, possible, not advised.
Okay. Someone says they have a burial plot in Washington State. Does that make a difference? I guess this is referring to the burial agent in that form. I'm not sure.
Not with the burial plot. The burial agent primarily handles the disposition of remains. If it's going to happen, if it happens here in Texas, then they're going to hire the funeral home, and the funeral home is going to make arrangements to transport the body up to DC or to Washington State. I would recommend that they take a look at the Washington State laws just to make sure that there's not some sort of companion document that they may need. If there's a burial plot, then there's probably going to be, it's a right of burial, basically. There's probably going to be a certificate that goes along with it that would indicate to me that we have a perpetual cemetery out there that's got its own rules. So I would at least check with the cemetery to make sure that your designation of burial agent is going to be given effect by the cemetery.
Okay. Last question that came through the chat. Who drafts a guardianship document?
So the declaration of guardianship is something that I would let the attorney draft because it needs some specific language. If a court appoints a guardian, then that's a document that gets drafted by one of the attorneys in the case, and then the court will sign it. And the appointment of guardian or the judgment appointing a guardianship is the document that's going to say who serves as guardian, what rights are granted the guardian, what they have to post as a bond, and what rights are taken away from the ward. As long as it's not an actual guardianship proceeding, then it's going to be the attorney who would draft the declaration of guardian as part of the estate planning documents.
Okay, looks like we have a few more questions I missed. Trying to see which. If you do not have children or family to name as executor, who else could you name for that? A bank agent or a lawyer or etc.
Yes. It depends on how big your estate is. A bank, the smaller banks are more willing to take an estate that is a smaller estate, but understand by smaller estate, I'm saying 500,000 and up. I did know of a couple of banks who would take an estate that was in the 150, 200 range, but I'm not sure that they're still taking an estate that size. So it would be nice to have a corporate entity. They're going to charge a percentage of it for handling the estate, but they know what they're doing. And if they mess up, then there's assets to go after. If the estate's not large enough, then you might look for a trusted friend who can do something with it. And if you've left a charity or a school, say a school, as a beneficiary for those funds, then you might actually reach out to that charity or the beneficiary, and they might have some ideas because they have at that point a vested interest in making sure that the estate is properly handled so they can maximize the benefit they get out of it.
Okay, someone is wanting to know if you have uh, a reliable or a place where they can search for a reliable or a trusting attorney lawyer for composing a will. If you have maybe a website or something that you might could recommend, I guess.
Sure. So I belong to a couple of organizations. Trying to think which one that I would recommend to send you to. There are a couple of websites out there where they have not recommendations per se, but they'll have attorney members. You can always go to the State Bar of Texas and do a search. If you want to do that, there's the National Association of Elder Law Attorneys. There's the NAEPC website. And then of course you can just do a scroll, if you type in who it is, you have an attorney for wills, estates, trusts, that type of thing, into the internet, and go down and just kind of take a look at their website and see, whether or not you like the feel.
Okay. Is it better to have someone added as a co-owner of real estate property or designated as beneficiary?
Depends on your facts. It depends on what you're trying to accomplish. Co-owner is just going to give them a part ownership of it, but it's also going to make them partly liable on it. So they're responsible now for a share of the property tax, which is, for Texas. So it's property tax, pretty high. Insurance, if somebody gets injured on the property, there's some immediate liability that attaches to being an owner. If the idea is that you want them to get the property when you die, then I would have that discussion with your lawyer to determine whether it's better to do a transfer on death deed or a ladybird deed or pop them into your will. Also depends on whether or not you've got a mortgage on the property and what you intend to have happen to the mortgage, whether it goes with the property or whether it gets paid out of other assets, or whether maybe you've got some kind of life insurance that is out there to pay it. So it just completely depends on your situation.
Okay. Last question. Someone is asking about a pet trust, or they have an endowment for a pet to a specific place. How would that be handled?
I love pet trusts. I think pet trusts are fabulous. I've done some pet trusts for horses. I've done them for dogs. I've done them for cats. I've done them for just about every kind of pet that you could have. There is actually a statute in Texas that applies for pet trusts. And so what you do is you can either have a separate trust that's just for the pet, where you have designated a trustee to handle it. You've left money there sufficient to take care of the pet. You give directions on what you want to have happen to the pet. If it's a pet that can be bred, then you want to leave directions on that. You need to make sure you've got a check and balance in place, because you don't want somebody who's a trustee drawing money out of the trust for 23 years if your pet life expectancy is 14 years. So you need to make sure you've got the little microchip and you've got some checks and balances in place. You need to say what you want to have happen to the money, if whatever money is left when the pet passes away. If your expectation is the person you name as a trustee, or you give the pet to, if your expectation is they're going to keep that pet and you're just reimbursing expenses, you can set that out. You can also make a provision in your will for it. So within your will, basically what you're doing is you're handing the person money and you're giving them the pet. The gift of the money is conditional upon them receiving the pet. The problem with that is once that gift's done, it's done. We don't have any duties out there. We don't have any guidance out there. You've just basically given away the dog with money. You can also leave a provision within a bigger trust for a pet trust section. And you can make the pet trust specific to the animals you own now or any animals you may acquire in the future. You can make it specific to the kind of animal. You can talk about, what kind of environment they have to be raised in. The only restriction on what you can do with that is you have to be reasonable in the amount of money that you've left. So understandably, everybody else who stands to get this money is going to be anxious to get this money and wants to make sure that you haven't set aside $1 million to take care of your poodle. So the court at that point would probably cut down the amount of money that you have left to the pet to make sure that it's, conducive with life expectancy and how the dog is going to, whether the dog's getting Purina or filet mignon every day. But the court would cut it down at that point. So that's really the only prohibition on it. But pet trusts are, they're a fabulous thing. I think they're great.
That's good. I didn't know that was a thing.
That's a big thing.
One more question, and then I think we're out of time. Someone is asking about disability. If you're disabled and can't afford attorney, are there any guidelines or websites or anything helpful for that?
The Dallas Senior Source, I think, has some reference for that. I don't know whether or not SMU or A&M law schools have a clinic to help with that. I think the Dallas Bar Association does have a clinic that can help draw up wills and ancillary documents. If you fall into, being a firefighter or a policeman or a veteran, then I think that there are occupation-specific references or referrals that you can go to help out on that. So there should be resources available to you. You just may have to look just a little bit.
Okay. Well, thank you so much. We appreciate all the information you've shared, Virginia. A lot of people say thank you and they really enjoy your DMN Dallas Morning News articles, and we appreciate all the information. Very thorough, and maybe we can have you do another program for us again in the future. So,
Absolutely. It was my pleasure. Thank you for asking me.
yes, thank you so much, and everyone have a great day. And please check out our programs we have on our website. We have more to come in the future. So thank you so much.